Rule 1.1 is the first substantive rule of the California Rules of Professional Conduct. It is titled Competence. This rule requires that lawyers perform legal services with competence. What does that mean? This continues my series on the rules of professional conduct, and if you want to stay up to date on the rules and also my other videos about law practice, don't forget to hit the subscribe button. The rule on competence says that a lawyer shall not intentionally, recklessly, with gross negligence, or repeatedly fail to perform legal services with competence. But you know what's okay? Negligently performing legal services with a lack of competence, at least once. In fact, the comments quote a Supreme Court case explaining that a single act of negligence is best handled as a lawsuit for malpractice and not as a discipline case. If you find this a little odd, you should make sure to watch my video on Rule 1.0 explaining that the purpose of the rules is related to lawyer discipline and not best practices. The definition of competence, though, is pretty vague. It means that the lawyer must apply the learning, skill, mental, emotional, and physical ability reasonably necessary for the performance of such service. So whether an attorney handled a matter with a lack of competence is going to be very fact dependent. But don't forget that to be disciplined, the lack of competence has to be intentional, reckless, grossly negligent, or repeated. In fact, a lawyer who lacks sufficient learning or skill can still take a case and gain competence by associating or consulting with a competent lawyer. If not, then acquiring the learning and skill before performance is required, or referring the matter out to a competent lawyer. But in an emergency, a lawyer can still provide advice or assistance if a referral, association, or consultation with another lawyer would be impractical as long as that assistance is limited. Again, this would be very heavily fact dependent.